right. So as I said in my previous life at ARL over and over to anyone who would listen, huge victory for the libraries, right? At the district court level, crushing defeat for the publishers. They're not here. I can't imagine why they wouldn't want me to moderate a panel with them on it. But Professor Landau, I'm going to ask if you can channel the publishers for us a little bit. This is Michael Landau from GSU Law School here in town, and I wonder if you could channel the publishers. You've just had this crushing blow. Why did you appeal, and what are your arguments now on appeal?
Okay. The arguments on appeal are basically, and I'll go through the four factors, and some others, but basically the similarity to the copy shop cases. The Basic Books and Princeton University Press held that it's not fair use, and they're basically saying that those cases are the same as the case with a digital use. Also, GSU pays a royalty for its hard copy course packs. They should do the same for digital. Two, not all works are informational. Some of the works have elements of creativity or have some expression in them. The judge today brought up brought up Darwin's Origin of the Species and said, is this informational or is it expressive or creative? They also brought up...
I'm sorry to interrupt, Mike. How many people have read that book? Okay, I have not, so I was like, I have no idea, but I'm sorry, I just wondered, so thank you, I apologize.
Steve, I read it in one of my literature courses getting my master's.
Really? Okay, interesting.
Yeah. Highly creative.
They had a problem with the 10% if there are 10 chapters or fewer, or one chapter if it's a longer book, and the market harm. They wanted to really look at the substitution effect, and they got into saying that you don't need to have a current market. There are cases that are out there that are saying the potential market. And that was one of the problems that they had. They also had a problem with the emphasis on the preamble in terms of saying that multiple copies for classroom use would be fair, where it's listed as one of those things that can be fair if you look at the factors. And that's basically it. They were also appealing the injunction. And at the oral argument, they were given a lot of heat on the injunction. Should the scope of the injunction be everything? Should the scope of the injunction be only these works that were infringed? What should the scope of the injunction be? And the court clearly did not want the district court to have to deal with enforcing an injunction. So there was a lot of that, but it was basically the arguments that I mentioned.
Okay, so those are the parties, but there were several amici who weighed into this case, and there are two folks on the panel today who were authors of briefs for amici, important amici groups. I wonder first, Bruce Joseph, who's a partner at Wiley Ryan. Bruce wrote a fantastic brief for several of the higher ed groups in Washington, D.C. And I'm curious, Bruce, if you can tell us, what was your interest in this case? What were the stakes here for you guys? And then I wonder, what are you hoping from your brief, especially after having seen today, what are you hoping that they go back and read when they get to their chambers that you wrote?
Well, I hope they read the whole brief.
What do you hope they reread?
Short answer, the whole brief.
Yeah, right.
Because they didn't seem to get it in the first read. So look, we looked at this case, obviously, well, first of all, disclaimer. I can't speak for any of the associations I was representing here on this panel. I wasn't authorized to do that. I can only speak for myself. So what I say doesn't necessarily reflect anybody else's views. Now that that's on the record, because I know you're being videotaped or being webcast, and somebody's probably actually watching, maybe one or two of the clients. From my perspective, it was important to put fair use in context. I think courts have lost sight of the fact, both put copyright in context and fair use in context. Courts have started to lose sight of the fact that the purpose of copyright law was not to grant exclusive property rights for private benefit. The purpose of copyright law was to foster an important public purpose. And the public purpose that's set out in the Constitution is the progress of science. Now, what does that mean? Well, the progress of science really meant, to those who were writing it in the late 18th century, meant learning. And when you sit back and you think about learning, what are we talking about here? We're talking about learning. There's nothing more fundamentally close to the core purpose of copyright than the kind of activities that were at issue in this case. And when you read the publisher's briefs, it's all about, these are fair use is a narrow exception to a property right. That's not right. Fair use is a fundamental part of the balance to promote the progress of science that Congress has enacted pursuant to that constitutional mandate. And we thought it was important to get that point out and get that point in front of the court. There's been a lot of focus recently following an article by Pierre Laval on transformative use, and you heard that a little bit today as the sine qua non of the first factor. And I think courts have been moving in the wrong direction on that. Transformative use is important, there's no doubt about it, but it's not the only kind of use that is or ought to be favored as fair use within the context of the first fair use factor, which is the nature of the use. Core educational uses actually are mentioned in the preamble. They're mentioned in Factor 1 explicitly, and they ought to be given a great weight, frankly, in the Factor 1 analysis, and we thought it was important to get that point out. We had a couple of less big picture goals that related to the nature of the work. These are academic works. There's at least one very influential legal scholar and now judge on the Seventh Circuit, excuse me, who has said that he has real doubts about the extent to which academic writing other than textbooks even needs copyright. Now, the academic associations certainly aren't going to go that far, but in terms of figuring out how the nature of the work works in the context of fair use analysis for academic uses, it's useful to sit back and look at the bigger picture. These are works written by academics with a goal of getting the information out in the academic setting. They're not textbooks. They weren't written specifically for course use. And I think the court had that wrong today when it was talking about, and I think plaintiffs have that wrong when they're talking about these works being written for coursework. No, they were written to foster academic discussion. And the authors, at least, are interested in having that academic discussion take place. That, to us, was relevant in considering the second factor, the nature of the work. I didn't see that that got a lot of traction today, so it would be nice if they read that again. And then finally, on the effect of the market for the works, typically when you're looking at copyrighted works, you're talking about an incentive to create and an incentive to publish. Here, the incentive to create doesn't necessarily come from the economics. Now, what that says to us is that that ought to affect the bar on the analysis of the fourth factor. And again, they didn't seem to get that very well. So what would I like them to look at? I'd like them to actually recognize that the uses at issue in this case were core academic uses that are at the heart of the progress of science and at the heart of the constitutional mandate to enact copyright law, that fair use is not a, quote, narrow exception, close quote, to a natural property right of the creator. Rather, it's an intrinsic part of the balance that Congress enacted to fulfill its constitutional purpose. And then we can go from there. And I can say more later, but that's it for now.
Great. And then Jonathan Band, who's the principal at Policy Bandwidth LLC, which is a law firm where Jonathan does a lot of work with libraries and other important folks in DC and around the country who depend on fair use kind of for their living. And I wonder, Jonathan, so you helped to file, draft and file, an amicus brief on behalf of the library associations, the Library Copyright Alliance, so that's the American Library Association, Association of Research Libraries, and Association of College and Research Libraries. And I'm wondering if you can sort of answer the same question. What were the stakes in this case for libraries specifically, and which parts of your brief do you hope the chambers go back, the court goes back to their chambers and rereads now after seeing today?
Thank you. So, in terms of the library issue, well, libraries at universities throughout the country help administer e-reserve systems. Many of them are very similar to the ones, the e-reserve system here at GSU. And as a result, this case is of enormous interest to libraries and universities across the country. So in our amicus brief, what we were trying to do was give a little context, because in many respects that's the whole point of amicus briefs. And as you heard from Bruce, I mean, he was giving a lot of the copyright principle big context, and we were trying to be more granular in terms of our context. So first, we wanted to give a little bit of the history of this case that was not in the record. In particular, that remind the judges that GSU had an initial policy, they were sued, and they changed their policy. And that new policy they adopted was virtually identical to policies that have been adopted at other universities around the country and that have been blessed by the publishers. That at Cornell and Hofstra and other universities, there was saber rattling. The publishers threatened to sue the universities. The universities changed their e-reserves policies, sometimes in close consultation with the publishers, and they came up with these new policies. And the policy that GSU adopted was very similar to those. No surprise. I mean, if I were GSU and I was, if I was counseling GSU after, the threats in the initial suit, I too would have maybe changed the policy. And what policy would I adopt? I'd adopt policies that the AAP had blessed elsewhere. That would be a logical thing to do. And so that's not in the record, but we wanted to basically really drive home that point, that this policy, the new policy at GSU, is really very similar to policies that have been blessed elsewhere, that have been adopted elsewhere and blessed by the publishers. The second thing is we wanted to stress that what GSU was doing was completely consistent with principles of fair use, best practices adopted by the Association of Research Libraries and then subsequently by other library organizations. To make sure, again, that it was clear that GSU is not an outlier, that they are in the mainstream, in part because that also enters into the fair use analysis. To what extent is the practice within the mainstream of practice in an area. It turns out that courts, various law professors who have studied all of the fair use cases have discovered that courts really do sort of take community practice into consideration. And so we wanted to inform the judges, A, of that principle that community practice is relevant, but B, to stress that what GSU was doing was completely consistent with community principle, with community practices. Another thing we wanted to do was actually get into the transformative issue, but from a slightly different perspective. And we certainly agree with everything Bruce said, that there is more to fair use than transformativeness, and especially in the educational context. But having said that, we figured, well, why not make the other argument to say, in which we thought was a very valid one, that even though Judge Evans found that these uses were not transformative, we thought that in many cases they very well might have been transformative, and that Judge Evans was too quick to conclude that they were not transformative. And so we explained why we thought that they could be transformative. The evolving case law with respect to fair use really focuses more and more on not just on the issue of recontextualization and repurposing. And we thought that in many cases, not all cases, but in many cases, the works here were being repurposed. They were being used in a different way from the way they were intended to be used by the author. And that repurposing, therefore, could be transformative. And that's really important, not only with respect to the first factor, but also with respect to the fourth factor, because courts have found that if a use is transformative, the fact that you lose licensing revenue is irrelevant. And so we thought that it was worth underscoring that these uses very well could be transformative, and as a result, not only does that tip the first fair use factor even further in GSU's favor than Judge Evans found, but it tips the fourth factor even further in GSU's favor. So in terms of what I would like the courts, the judges to see, again, it's all three of those points. One, again, remember what this policy is, that it's in the mainstream, but also, especially with respect to that, in the discussion today, they were very quick also to just say, yeah, this isn't transformative, and move on. And I would like them to think maybe, well, yeah, maybe this, some of these uses very well could be transformative in the impact not only on the first factor, but also on the fourth factor.
Great.